Good afternoon, everybody. Thank you for joining us for the POPI Act Compliance Masterclass today. This masterclass is going to be for 1 hour. My name is DB.
Okay.
Just a few simple guidelines. We are actually overwhelmed by all the registrations. We have a lot of registrations, and please do mute your microphones. And we are recording this for future use. So all of you and whoever has signed up for the masterclass are going to get the recording. And we will share materials as in the presentation deck as part of the recording. It will be there. You could use the chat to type in your questions, and we would answer all your questions for sure. Okay, and having said that, mute your microphones. If you do not want to share, if you do not want the video to be on the recorded replay, switch off your video. That would be really nice. Okay. Having said that, quick disclaimer. We are a software company, and we are not providing any legal advice. Of course, we have Brad Hammer, who I'm going to introduce on the call, but we are not providing any legal advice. If you do need legal advice, please talk to your attorney. Having said that, my name is DV. I'm the founder and CEO of Assert, and we have Brad on the call with us. Hi, Brad.
Hi, excuse me. Hi, everybody. I'm Brad Hammer. I'm Chief Privacy Officer at Assert. I'm a lawyer. I've been working in the data privacy, data protection space for about 10 years now. Worked a significant amount in Europe on the European privacy law and helping compliance with that, which was what POPI was modeled after. So I'm happy to be here.
And we wrote the book on the POPI Act compliance. I've been in the security business for a long time. This is my third company that I have set up. And so we are here to help you guys. Now, having said that, let's jump right into it. We don't want to waste significant amount of time because I know a lot of you have a lot of questions. The fun part would be actually going through the questions. At least for Brad and I, the fun part would be actually answering the questions.
Right. Yes.
Now, having said that, we expect you to take away a few things from this masterclass, and it's not going to cost you a dime, right? You should get started now, and you should at least complete your initial implementation based on what we have seen. We've seen a number of customers complete their initial implementation within a day or two. So at least get the information regulator off your back. Those are going to be the key takeaways from this masterclass for you. We focus the masterclass session and this entire session on implementation. We focus less on the history of the law and all the nitty-gritty detail. We actually filter all the details for you and focus on the implementation. How do you get compliant and be done with it? Okay, that's our intention. So we're going to walk you through all of those items that we talk about. The framework, what is the POPI Act? How do you treat the data subject requests? What do you do with respect to direct marketing? What do you need to do with respect to data collection and special processing and protection, etc.? Okay. Now, the big question, Brad, always comes down to this, right? Do I have to be compliant, right?
Yes.
There are no exceptions to this. Yeah.
No. So I will inevitably, we've done these a few times. There's the question of, I am a sole proprietor accountant. Does this apply to me? We are a nonprofit organization. Does this apply to me? We're a school. Does this apply to me? Yes, and yes. It applies to everyone. And so there are certain minimum things that you must be doing regardless of the size of your organization, regardless of how much personal data you're processing. If you're located in South Africa or you're processing personal information of people in South Africa, it's going to apply. So we'll say that at the outset. We'll probably still get the questions because sometimes stragglers come in late, but just for everybody's reference.
For everybody's reference, it applies to everybody.
Yep.
And it actually, if you really look at it, it's quite simple, right? This is about respecting consumer privacy rights
Yep.
and protecting personal data that you would collect, whether
Right.
you collect as a course of your business, you collect as a course of your marketing, whatever approaches and the purpose of your collection might be. And also, making sure that you lawfully process the data. As in, if somebody
Yeah.
says, hey, take me off of my list, you should take them off of your list. We get those take us off of your list requests from people who have actually been on our masterclasses before,
Right.
and we do
Yes.
that, right?
Yes. Yeah, exactly.
We don't want to get any more emails from you. So fine, no, we'll take you off of the list, right? So that's what it is about.
Yeah, I mean, keep in mind as we talk through this, there are certain things that are maybe different or new in terms of documentation you might need to do. But if you are generally operating a sound ethical business or sound ethical nonprofit, in the sense that you are respectful of your customers and that and their wishes, and then you're not going to have aside from increasing maybe a few documents, it's not going to be that much of a change in terms of what you need to be doing. So
no. So that's the idea. And I mean, I can go through this with respect to when it started, how it happened, what happened to PIA, why is the information regulator taking control of the POPI and PIA together. We could do all of that stuff, but just briefly, right? The enforcement has started. The information regulator is giving a little bit of leeway to people, but they're actually starting to do the enforcement. And that we have seen, and we have actually noticed that they're going after larger companies to figure out whether they're compliant or not. They process the data and personal information properly, right? Now, having said that, Brad, this is a really critical piece at this time, right? Why should anybody get compliant?
Yes.
Earlier, this was about avoiding fines and preventing data breaches and the cost of data breaches and stuff like that. But now, nearly every RFI, RFP, every tender that we see has POPI as a requirement, right?
Yep, exactly. It's becoming, again, and this is common in any place where new laws come up. There's certainly the law and the regulator that you have to comply with, but the degree to which you are doing business with other businesses or the government or anything like that, they will expect that you're POPI compliant, and they're going to expect you to demonstrate that. So that becomes as much a part of you staying in business as anything is making customers and partners and that happy.
And having said that, there is no organization that's actually saying, oh, we will certify you to be POPI compliant. So let's be very careful with what you see in the market. Becoming POPI compliant is not certified, right? Because nobody can certify that for that matter. Now, how do you demonstrate that you are compliant? There are a few things that you need to keep and do with respect to the policies and how you implement your policies and stuff like that we will discuss, right? Now, having said that, there are, of course, the fines and the cost element of it, but we have not seen significant portion from this perspective right now. The regulator has barely starting to impose fines. It's likely coming down, but we haven't seen it so far. Okay, so just to keep that in mind. The bigger issue I see, and Brad, you've seen this in your day-to-day practice today, right, is the cost of data breaches. If you have a security breach, it actually costs you a lot more money.
Yeah, exactly right. That because of the new law, and this is happening in a number of jurisdictions, there are certain costs that individuals are entitled to, or that you might be fined based on a data breach that's taking place, and increase in sort of in litigation in that space as well. So I think you're right. I think that for the most part, the regulator is really focused on, if they're doing any kind of investigations, getting folks compliant. But the risk of data breach and the cost of data breach goes up exponentially when there's a new law in place, because it gives individuals additional rights. And gives them certain things they're allowed under the law.
And one of the big reasons for that is the cost it takes to actually go inform people that were impacted with it, right?
Exactly.
That's another reason. Of course,
that's an obligation built in.
That's an obligation. It's a requirement that you have to go, tell people that the data got breached, and here is what they can do about it, right?
Yep.
Now,
Exactly.
having said that, we talked about will the law be enforced? Obviously, at certain point of time, it's going to get
Yeah.
enforced, and it is
Yes.
being enforced that we see. The regulator is fairly well funded, they're staffed, and they have a lot of open requisitions for
Yep.
hiring more people for those investigations. Think about it this way: if one of your consumers and customers or partners files a complaint, the regulator is going to open an investigation. The fact that they
Yep.
open an investigation itself will cost you money
Yes.
because you need to respond to that investigation, right?
Exactly.
So it's a good idea to be more preventive than be reactive, right?
Yep, and it goes along with and the data breach discussion we just had as well. If you have
Right.
any kind of data breach, even a minor one, and then you're reporting that outward, that is if the regulator has to choose a place to start investigating, they're going to start investigating in places where they think that someone might not be doing their due diligence or acting correctly. And so that's exactly correct.
Exactly. So let's see how you could become compliant and you could stay compliant, over the years, right? There are 4 areas, and we talk about this, Brad, all the time.
Yep.
You need to address your policies. You need to address how you're processing the requests coming from your data subjects. Obviously, all of this needs to sit on an infrastructure where you're lawfully processing your data and who you're sharing the data with and how you're sharing the data with, and obviously protection of your data. So is the person you're sharing the data with also protecting the data? So there is that underlying elements that needs to come into play. But overall, it's simple. You need to have a policy or policies depending on the type of stuff that we have. You need to be able to process the requests coming in for privacy of individuals, and you need to lawfully process the data and then protect the data, right?
Yeah, exactly correct. These things all go hand in hand, right? In the sense that if you're doing one and you're helping with compliance with the other, in the sense that you have a good privacy notice and good notices and then that's going to make it easier for you to process your data subject rights because you've made those public and you're prepared to do so because you know what data that you have. And then the data flow helps you know what to put in the policy and the rights that you need to go along with. And then IT and like a lot of the protection pieces sit over the top of all of that. And the data flows also help, just like you said, DB, one of the key elements and biggest risk areas is knowing what third parties you might be sharing data with. And that's a commonplace risk area for compliance as well as potential breach is one of the more common areas of a data breach is through a third party.
Exactly. Yep. So all of these are, we have this implementation framework, obviously, all of this kind of break down into multiple activities. Some of them may apply to you, some of them may not apply to you, depending on the business, right? But overall, you really need to start to work with policies and policy definitions and rights management and changes in the process within your business on how you do things, right? Eventually, you will start to worry about, while I don't intend to say data security is less important or more important, but the easier things that you do, the better it is for the entire project to get done fast, right? So first address the policy issues, then rights management, then your process change, and then focus on security, because security is an ongoing process. It's never ending, right?
Exactly. Yep. Yeah. You'll show some of this, but there are really simple ways that like you said, in a couple of days, you can get some of those policies mapped out and data flows started and all of that stuff. So
absolutely. And of course, you need to have an information officer designated, and that's very important. While earlier in the implementation of the regulations and the law, the regulator had mandated that an information officer need to be registered. They have removed that mandate as a requirement. If you do not register an information officer, they will by default assume the CEO of the company is the information officer, and the CEO of the company is actually registered with the company registrar anyway. So by default, that would become the case, right? Now, having said that, the question is about data collection, right? People have started to think and say, I've seen a lot of Facebook comments and a lot of people commenting with us and says, hey, then how do we do this, right? We need to collect personal information. We need to send an invoice, right? So, Brad, I mean, this doesn't stop the business from doing the things that are required for the business.
Absolutely not. It certainly doesn't stop the things that you need to do for your business, because there are in terms of, let's say someone has a deletion right, there are certainly exceptions for you to be able to do business. It's not about necessarily significantly changing the way you're doing business. It's about properly disclosing that and being receptive to consumers' rights in that. So you can certainly do that. The one exception being is some of the new rules around direct marketing in that, and we can get into that in a little more detail, or at least, that's the one caveat that I would say that where there might be some differences, but otherwise, you can continue doing business the way you're doing business. The law is not intended to make it impossible for you to do business.
Right?
So,
yeah. Because the laws are not intended to stop the economy from moving forward.
Right. Exactly.
Provide different types of protections.
Right.
Exactly. Now, having said that, and it comes down to the direct marketing piece, Brad, right? The most important thing here is you must collect data directly from consumer. So, for example, we have this masterclass. The data is collected as part of the masterclass in the specific purpose of helping you navigate POPI compliance, right? We would not and we will not lawfully use the data for any other purpose than the purpose of POPI Act compliance. Right. So we can't turn around and actually use your information or anybody's information that we have so far and basically start selling you books. I mean, books may not be the right one. Start selling you electronics goods, for example, right? So that's the whole idea there. We have to collect it directly from the consumer, and we have to use it for the specific purpose of collection, not right, Brad?
Yeah, exactly right. And it's one of the things that the key elements here that you do need to consider if you're considering a new, let's say you've collected a bunch of information for a specific purpose, is the use that you want to do, is the next thing that you want to do with it within that purpose, within that clear business purpose. And one of those questions being, direct marketing and the need to consent to direct marketing, because if someone has no expectations, for example, what we commonly use is buying and selling of email lists solely for marketing purposes. Because the likelihood that person has provided consent to you to market to them is not necessarily accurate. So that's there are certain and it's not to say that you can't use data in certain ways, but you need to be asking these questions and ensuring and either consulting with your attorney or looking at the law or looking at your own policies to say, what does this mean in terms of what we have? So exactly.
Now, having said that, I mean, obviously that then comes down to the rights of the consumer. The consumer has the right to unsubscribe or opt out. At the same time, they also have the right to opt back in. Okay, don't forget that, right?
Yep.
And they have the right to know what information they have about you and stuff like that. So, so all of these rights, right to correct, right to delete, are all available for the consumer. Now, the questions really come down out of the woodwork on this one. Well, if I delete the information, how am I going to send them an invoice? Right? Yeah.
Right. Yeah, exactly. I mean, you're not, if you look at the law, there are a number of exceptions to, frankly, all of these in terms of like the right to delete being one of the more common ones in the sense that like, if you have an active business relationship, and you have a contract that demonstrates that they owe you some money or something like that, they can't get out of a debt that they owe you by saying, please delete my information, or get out of a contract. If let's say you have an annual agreement with them, you have a year-long contract with them, they can't get out of a contract by saying delete my information. That's one of the most common examples here in terms of that. But even things like right to know, and that in terms of if requests are excessive, if they would cost, if you're not required to reply to a request if it would for some reason cost you $100,000 to reply to that. There are certain exceptions within that, and on a case-by-case basis, you can look at those, and those are few and far between and somewhat uncommon in terms of that there aren't a lot of those circumstances where those are coming out. Right. So those truly are exceptions that you would look at under the law when they come up, right?
Exactly. And you need to provide them a way to exercise those rights. Either you do an intake form on your website, or you do an email, or on your email newsletters you send out, like subscribe, unsubscribe. These are some of the common things that you could use to actually have your customers and consumers exercise these rights, right? Yep. And the responses need to be reasonably quick. Yep. I mean, you can't take a year to respond to a deletion or a correction request, right, even if you're not doing it. If you're not doing it, send them a note back saying, sorry, we can't delete. We have deleted all the things from our marketing side of it, but we can't delete from our finance and various other pieces, right? You have to respond. You have to be reactive in a reasonable time frame, right?
Yep, exactly right. And I mean, and and keep in mind the time frame. Part of that is even acknowledging initially to help reduce your risk, to say in the first couple of days, if you can verify a request, we've received your request. And a part of that is then also, if you cannot verify a request, for example, I've assisted clients with this, and all we'll have is the email that they sent from, and we'll need some additional verification. And if they never respond with that verification, that you're not obligated to reply unless you can confirm who the person is. For example, if someone requests a bunch of information, a right to know, you don't want to create a data breach scenario by sending it off to somebody when you haven't verified that they're actually the person that's making the request. So
yeah, you don't want to dig bigger holes
right,
for yourself.
Exactly.
Right.
Exactly.
So you got to be careful with some of this stuff going in, because talking about breaches, right? The impact of breaches is severe in South Africa. It takes 51 days on an average to contain a breach. It takes 6 months, by the way, on an average right now, to identify that you did have a breach.
Right.
Okay. So it takes a long time to figure out that you do have a breach. And then it takes more time to actually figure out how to get out of it, how to improve it, how to contain it and things like that. Then that's the one that's actually costing you.
And to be clear, this is not we're not being critical of South Africa. These numbers are actually fairly typical globally in terms of when you're looking at averages for response. But because we have the numbers specific to South Africa, we felt it's applicable to provide them to you so that you have that as a reference point. So.
Yeah, but think about it this way, right? Ransomware. People are asking for Bitcoin in ransomware. While Bitcoin may be cheaper, but they're asking for the same amount of money.
Right.
So you need to buy more Bitcoin. No, so this is the data protection portion of it, right? So you need to worry about data protection, potentially from IP theft, intellectual property theft, and it's typically what we have noticed is you should have at least some good password policies, some good security controls and mechanisms. And those are the kinds of assessments that we help you, and you should be able to do pretty quickly and easily, right? And we cannot leave this conversation without mentioning some type of liability coverage that you need to take, right, Fred?
Right. Absolutely. I mean, cyber liability insurance is becoming quite common and becoming, we talked a little bit earlier about contracts, and that it's also becoming a common contractual requirement in the sense that especially if you're in the B2B space or something, to say, if you're processing personal information, we expect that you have XYZ amount of cyber liability insurance. So
absolutely. And by the way, it is not very expensive to
Yep.
purchase cyber liability insurance from insurance providers in Joburg and Durban and other areas. So, Brad, I want to stop here before we jump into how SRT can
Yep.
help and see if we can address some of the questions that might
Sure.
be pending.
Yep, we have quite a few. So so I can touch on those that have come in so far. Oops, I just moved the window. There it is. So can you touch on employee rights? Who has legal access to their data and how can this be protected? What are directors' rights to access this data? So, I mean, from an employee rights, data rights perspective, it's similar to what it is now in the sense that if you need the data in order of an employee in order to employ that person or consider someone's application for employment, or for, you know, even after termination, if for tax purposes or other legal purposes you need it, that remains the same, right? They might have certain rights that they can exercise in that, but internally, it's a matter of thinking about, okay, how broad is the access to employee data? You might want to consider whether or not it needs to be reduced if, say, it's living on a server and anyone can access all of the employee data. But for the most part, if someone needs access to certain employee data to do their job, that's a fine piece of having access. And then, you know, managers, directors, CEOs, and that there's usually a fairly good argument that they would need information about their employees. So
yeah, I also see another underlying question there, right?
Yeah.
Now, who can access personal information is how I see that question as.
Sure.
And that's more a data security, data protection question than a lawful processing question. Obviously, you don't want people who don't need access to have access, of course, right? Because, for example, you know, we do know that South Africa does not have salary transparency laws, right? So as a result, if you want to, as an employer, you have a policy not to disclose salary of, you know, employee A to employee B, right? You want to make sure that salary data is secured, for example, right? So that's a data protection issue, and you should have, you know, some kind of policy in place and some kind of controls in place to ensure that data protection is addressed there.
That's a great point, because it's a data act. You know, if you're using a program like Workday, or I think Oracle has some different versions
of Zoho CRM.
And so there are usually within those, there's access controls that you can set up, and that's a really great point, that it trends more on the security side in terms of access controls being a part of that. So do you need to register deputy information officers? Not necessarily, no. I mean, the primary purpose of registering the information officer with the regulator is so that they have a singular point of contact. So if there's an issue with your company, they know who to call. But I also
want to answer that question slightly differently as well. It's not as if you're getting two different answers. I see, do you need to as the main thing? No, you don't need to anymore. Are you required to? Is it a mandated thing from the information regulator? No, it's not. As of, you know, they may change their mind later. Then when they do change their mind, we'll let you know. But it would be a good idea to register, and not a requirement.
What is the information regulator doing about debt recovery companies that buy bad debts written off? I mean, I think, you know, without getting into the weeds on that specific question, it's going to be dependent on, you know, what sort of the contract says with regard to buying and selling of that debt, and what the original debt, you know, obligations were in terms of that person. So, I mean, it's not going to necessarily prevent people from doing business. It's a question of what, you know, as long as you're doing business in a compliant manner, I would say is probably okay. But I don't.
Yeah. So if Standard Bank has a lot of bad loans, they might want to hire a third party to actually do recovery of the loans. And when they do that, it's a business transaction that they assign the loans to that third party. When they're assigning the loans, and they're legally assigning the loans, they're lawfully assigning the loans. So those debts or loans do go to the third party, and that third party now has, obviously they need to be compliant for POPI, of course, but they have the right to go collect.
Ali, saya ngomit lang. Gusto say unmute.
Somebody unmuted themselves, it sounds like there.
Yeah.
What is the impact of POPI on doing primary research, including desktop research? So, I mean, it depends on if you're talking about a business doing research about customers, that needs to be within the scope of what they've disclosed. If you're talking about like universities and broader research that's in the public interest, there is some more flexibility in that. It's going to depend on the research, and that's really a case-by-case basis. But most of these laws have allowances for, let's say it's a university doing public interest research, that there's more of an allowance for processing of personal information than, say, in the consumer space, where a business is going to be limited in what they can do with it.
Yeah, I think you should also look at the code of conduct typically published by the regulator for your specific case. And they do start to publish the code of conduct associated with, for example, research, medical research, or, they actually did address the credit rating agencies' code of conduct about sharing information between banks and credit rating agencies recently.
Is the POPI Act only applicable and governed to South Africans, or does it apply internationally? So it's slightly different if anyone has worked with GDPR than GDPR, where GDPR is, it applies to any company that is selling to within Europe. With POPI, you have to have be making use of some presence within the country. You have to have some presence, either a location in the country, or if you have, actively contracted that you're making use of something within the country. So it applies to all people in the sense that, but if you are a business that is solely located in, let's say, the United States, and you just happen to occasionally get customers from South Africa, that would not necessarily apply. It's sort of a case-by-case basis you have to look at there.
If you have one employee, for example, it applies.
Right. Yes, that's enough. So is it possible for a data subject to withdraw part of the consent given? Yes. I mean, generally the rights are they can object, they can withdraw consent, they can object to all or a portion of the processing, or they could ask for deletions. I mean, there are, again, exceptions in the law depending on your relationship with that individual. Again, they can't object. They can't buy something from you and then say, I object to processing for you to send me an invoice, right? Like you can't do that. So,
I object to you. I object that you take money from me, but send me the goods.
But a great example of objecting to or withdrawing consent for part of it is that they may consent to the processing to do business with you. They may withdraw consent for direct marketing because they don't want to get marketing communications from you. So that's a great example of where a partial objection or partial withdrawal of consent. Someone asked if they're getting a lot of spam calls since the act was enacted. Sounds like that, yes, is the case. That the problem with that being, we experienced this, I experienced this as well, which is if they are not legitimate businesses and they're scammers, there's no way to catch them anyway. But
I wouldn't use the word scammers. I would use the word spammers, right? Spam is rampant.
Yeah,
and it's gone up.
Spam, right.
It's gone up like 5 times approximately during the COVID time, and it has not come down since. Okay, so it's not because of the POPI that spam is happening. It's because of the market conditions.
Yes, that's actually correct. Yeah,
that spam is happening.
It's just bad timing on that. Let's see. Does your POPI manual have to be lodged or with the information regulator? Not. I mean, it needs. No. They have the right to ask for it, but I think that it doesn't typically need to be actually sent. It's a document that you should be ready to provide and make publicly available if need be, but you don't necessarily have to send it in to them for review.
So I want to clarify out here, right? What is a POPI manual? Okay, there is no single document called a POPI manual as part of the regulation. You do need multiple policies. You do need a PIA manual, which is under a separate law, which is outlines how a user can get access to data. Okay, so that's one. And obviously, the rest of these things are about policies like privacy policy, website terms of use, social media policy, and things like that. So if you consider all of them together as a POPI manual, yeah, you could use that word, but there is no definition of a POPI manual.
How to deal with POPI compliance in terms of bid documents submitted by tender bidders. I guess if there's a question of, are you asking for how compliant they are? You might ask for some compliance or might need to demonstrate compliance as a part of a bid process. I mean, you can, again, if there's personal information on a bid that is valid to be processed until such time as you're either accepted, or if you're rejected, then there should be a logical period that data is deleted.
Yeah, maybe
DB,
that
I don't know if you have
question
any other.
that could get a little bit more specific on exactly which one how are you referring to it?
Yeah.
Are you bidding on the tender?
It sounds like that it sounds like from that they're accepting bids. In which case there might be, that'd be something we would call, in the lawyer space, due diligence, right? You might have a questionnaire, a privacy questionnaire that you're going to ask bidders to fill out. And then if there is personal information on the bids, you can of course process that because that is a part of that process. You shouldn't be asking for more than you would need in order to process or consider it, but that's exactly so. Is there an example of a policy document that you can use as a guide for accounting firms? I mean, so within, and we'll address a little bit of this as we talk about the platforms more, there are some basic policy documents in there. As far as something specific to an accounting firm, that's something you'd need to address on your own, but there's some basic policy documents available on a cert. What careers can one explore with POPI compliance background without any registration certificate, et cetera? Familiarizing yourself with the law and taking classes on is certainly something you can do. And there might come a time where there are official certificate. When we say there isn't an official certification, there is not something that the regulator has said, if you get this certification, you are POPI compliant. You might be able to get a certification through a trade school or a college or something that says that you've taken a certain number of classes that make you more, but that's a different scenario. Does every office require a paper shredder?
It's a good idea. It's a good idea.
It's not a bad idea. You need a way to securely get rid of paper. You can also, there are also third parties that you can pay to shred paper for you, but you need a way to securely destroy paper aside from just throwing it in the trash if it's got sensitive information on it. Is it necessary when drafting an operator agreement to have clauses in the agreement? I think just generally with regard to agreements under the POPI Act, if you're engaging a third party and sending them personal information, you are required to have certain things or ensure compliance with POPI within that agreement. And that might take different forms. It might be an addendum. It might be specific clauses. But you should be addressing privacy and sort of operator agreements, that kind of thing. Are we allowed to use programs like Traceps for telephone numbers? I'm not familiar with that. We pay. I will answer this question. I'm not familiar with that particular company, but they said we pay for it, so I believe it's allowed. Just because you pay for it does not mean it's allowed. There are any number of companies that would be more than happy to sell you email marketing lists when you actually might be violating the law by selling those lists. The same with buying and selling of phone numbers and using that. And now if it's some sort of screening, I know, for example, there's like a do not call list in certain jurisdictions where like you have to take your email list and then pay to then have it screened so you're not calling, that kind of thing. So I would say just think about, even if you're paying for it and there's a vendor offering it, that does not necessarily mean that it's allowed under the law. Are there any excuse me, are there any specific laws within POPI that focus on collecting pupils' data, things like emails?
Pupils, you mean student data?
Student data, I would assume. If the students are if the students are children, there's a heightened level of protection that's given to that data. Yeah, there's parental consent and that you have to get in that sense as well. There's not a separate law for student data. So for example, in the US, because we don't have a POPI style law, there's not a comprehensive law. There's a federal student privacy law. There's not necessarily that in the same sense, but students and children's data is considered sensitive.
Yeah.
If the information is online and public, if they ask us to remove their data, how would that work?
Well, if the information is online and you put it out there, that's a breach.
Yeah. Right.
If the information is online and they put it out there, that's their problem.
Right. You don't have to, if you got it from a public source, you don't have to go trying to get it deleted from there. You can tell them where you got the information from, but you should still stop using it, right? Because they can still ask you to stop processing that information, even if you got it from a public source.
But again, the best approach is to collect directly. Don't try to get from a third source. A public source is a third source.
Right.
Okay. So you got to be very careful about that.
Yep. Okay. I got a couple more that just came in. I think we can get through some of these. Can an employer monitor all data on an employer issued device, such as laptops, cell phones, if there's a policy? So as long as the disclosure is appropriate, I would say generally yes, but and this was the case in Europe, for example, when the law was new, it was okay, as long as you're disclosing, you can do this. But with enforcement actions and court cases and that ability has actually shrunk down in the sense that you still need to be considering, is it reasonable for me to be monitoring everything they're doing? Is there a way for me to still protect the company data and not monitor everything they're doing? And so you should still consider those questions.
Yeah, Brad, I focus on consent.
Yes. Yeah.
Right. You got to get consent. If before the employee joins, you acquired their consent because they're an employee. You're doing certain things like collecting data, and they're using personal data. They should not use personal company property for personal information, etc., etc. So those are the things that you need to be. So I would focus on that. The person is asking about without specific permission. Without permission, that's not a good idea. You have to basically say, this is our policy and you need to consent to it, right? So it's part of the employment process.
Yep, exactly. All right, there's just a couple more that I think we can get through quick. I'll fire off a couple of these. Will there be more masterclasses similar to this? I believe so. I don't know that we have one on the calendar yet, but keep an eye on Assert. We can, if we do another one. As a bookkeeper, what do I need to do to be compliant? You still need to be compliant. It depends on if you're an independent bookkeeper, it depends, right? And so I would say, look at what we have available and what's in the law and that.
Exactly.
So
ESET can help you, Angel and us, we can help you out. We'll talk about how we help shortly.
Yeah, and then the act refers to regulator where you can refer complaints. There's the information regulator. If you Google South Africa information regulator, they have a website. That's where that goes. They're a separate appointed body, a governmental body. Is it legal for companies to use contact details that they find publicly, basically due to cold calling?
We talked about that.
I hesitate to say yes. I mean, I'm not going to say no in all instances, but I say no unless you can find a good reason why you think you can do it, and that's something you need to talk about with your lawyers. Is Eastern countries bound to POPI Act, or do they have their own laws in this regard? I mean, if it's within if they're subject to the laws of the Republic of South Africa, is the question here. So I'm not sure. But yeah. And then do you know of any courses that cover the act itself? So I would say the Assert has an information regulator training that is a longer training that we have available. That is
officer training. Yeah.
Information officer training. Yes. That is a little bit more in depth in terms of the act, but yeah. Okay, that actually gets us at the end of the current questions.
Oh, that's still not a record. I mean, that took longer time. This is
I was going to say, I'm sure that some more might trickle in, but let's move on to the next.
Let's move on to how we can help
and then I can save the next round of questions if we have more time at the end. So, and you can always email us or message us if you have questions as well. So.
Yeah, the good news is we can help you, right?
Yep.
We automate the POPI Act compliance. We provide the software to do that, and We do that by basically providing you a recipe, a step-by-step approach where you can do it yourself. Obviously, we are here to help you, but you could do it yourself, right? And it is because we have done it with hundreds of customers. We have a number of POPI experts who can call in, and obviously we have the book, and that's the expertise, and you can see the expertise come through our conversation here on the masterclass as well, right? Now, we do provide, as part of the software, 3 packages. The Pro package, which gives you all the policies and manuals, and the policies and manuals on our system based on your company profile. We auto-generate those policies. So you don't have to sit there and keep typing and writing and templating and all of that stuff. Our system will generate them for you, and you can use it in whatever form you need. You could also upload it directly on your website. Okay, so we provide you a plugin to actually do all of that. So you don't have to go running around saying, oh, I just changed my policy, or I added a new system, or I added a new employee. We need to change that. All of that is available with us. Okay, we will help you with your gap assessment. We will help you with all your data subject requests and managing and processing those data subject requests that we went through. We get your website ready for compliance. We go through your data flow mapping, and that is done using our AI in the back. We provide you the information officer training that Brad was just now talking about. Okay, and the privacy policy and the cookie policy and the list of sub-processors and the employee privacy notice that you need to put out. What should be your standard operating process? A manual we give you for your data subject request operating process. You need to have a direct marketing policy that is published. You need to have an IT security policy, which is really important. A social media policy. If you have a data breach, what do you need to do? What is your first step? What is your second step? All of that stuff. And somebody was asking about tenders and agreements, etc. So as part of your tenders, you could ask your vendors to, sign up a data processing agreement, which is separate or part and parcel of the overall agreement that you might have. So all of this and more are included in the Pro package. Okay. Now, obviously, you could do a Lite Plus or Lite package, and you could get started with it and see how far you go along and upgrade. But our Lite Plus actually includes the information officer training. If somebody is only interested in the training portion of it, they could just sign up to that as well. And doing all that stuff is very easy. Okay. And Angel will drop you the website where you can sign up. It's simple. It's assert.io. Okay. And you can just follow onboarding process, and you're done. With the base initial stuff, you're done in about 15 minutes, maybe 20 minutes with what we're doing. And that's the power of the artificial intelligence system that we have built. So let me show you a quick demonstration. Okay, and let me share. So you can see, I'm going to log in because I'm already signed in into the system. And when you do sign up on assert.io, you go here and you sign up on assert.io. It'll help. Okay. And you add new. And you basically say, hey, I want to select that, right? South Africa jurisdiction. And it will present to you the Pro, the Lite, Lite Plus. And some of you may have requirements for ROPA under GDPR, but if you have, we can talk about how that works. You could select one of these, for example, and you will be presented the whole company profile. You type in your company profile, you click next, you'll get the download of the registration form or how to register your information officer. You can walk through that video that Brad and I have created for you. Okay. And then you basically, after you do that, the key piece here is then selecting your data. what type of data you have, right? If you have an HR system or something else, you basically, let's say you have an email system, right? Outlook, selected Outlook, I guess. Microsoft, for example, you could select Microsoft, you could select Zoom if you have that, and add that to the catalog. We have enough in our catalog. I'm not going to do that. And once you do that, your PIA manual gets created, auto-generated for you. Okay, all of this information is what you just provided. And this is the information that our AI system just brought together with respect to your purpose of collection, your categories of collection, all of this. The entire PIA manual is all ready for you to go. You could download it or you publish it. Again, the same thing with your website terms of use, right? And then we provide you a WordPress plugin for your website. You can download the website so you can actually publish your policies directly on your website. It's done. Okay. Obviously, you have a few other things that you could potentially do, but you could do that over, over the next day or two. Okay. That's it. You have POPI compliance addressed. Okay. I mean, you select Pro, you have other policies and documents that, like we were talking about here. Okay. Having said that, I want to leave for any questions that you have. And Angel will drop a one-on-one pre-meeting with me.
Yep.
If you want to learn more about that package, she will drop a Calendly link on there. Okay.
So the only additional question that looks like it's coming so far is in terms of publishing the PIA manual, is that on your website? If you don't have a website, where do you publish that?
It should be published on your website, your company's website, not ours. If
right.
That's what you're meaning.
Yep.
We are a service provider to you, and you will publish on your website, and we will service that through that particular approach. Okay.
Yeah. And
yeah.
Well, and I was going to say, and if you don't have a company website, I mean, I would assume that's because you're a storefront or maybe referral-based, small business or something like that. Just having it available for someone to request it at that point, if you don't have another place to publish it, should be sufficient. So, does the system, I assume you're talking about Assert, provide for data mapping where you can import your data and map it to categories? Do you want to maybe touch briefly on how that works, Stephen?
Yeah, the way it works is, we've run this machine learning in the back, so we know what categories it belongs to and what purposes you're doing, depending on the type of information that we have noticed. We do not have to look intentionally. We decided not to look into your data because then it will increase our liability with you. So, and also it takes longer time to do all of that stuff. So
yeah,
we avoided that, and we have a system that avoids that, but gets you all the policy data nearly about 95% correct.
Yep.
95% is a lot, by the way, to get correct.
Somebody said, I already registered for the package and find it extremely user-friendly. I will just read that out loud because I think everybody should hear that.
Thank you very much. It's nice to hear that.
I think that they said, where can the information officer be done and what is the cost? I assume they mean the training. So if you sign up for the light, we have a pre-recorded training that you could do on demand. In addition, we may be doing another live one at some point, but we do have a pre-recorded. It's a pre-recorded training that is on-demand training. So,
and we would likely do an information officer training soon enough, and we will provide that to all the people who are part of that Light Plus package.
Yep, that's good. It's a good thing to be updating as things develop. But
and from what I understand,
right now, the current one that we have is good. So yeah.
Right, from what I understand, people are interested in to get that certificate of participation in the training signed by you and me, I guess. Okay, so right. We probably do that too.
Excuse me.
This is about the information officer, not the Masterclass.
Right. Yes. Yeah. The information officer training. So yeah, I mean the you're required to get some training. There is not, and again, there is no, if someone is out there saying like, this is the official, this certification or registration is official with the regulator, that's not the case. But demonstrating, having something to demonstrate that you have done a certain minimum amount of training is beneficial. Just like any documentation is beneficial if the regulator comes knocking, to be able to say, we have done this training, you can do, or one of the things we always say, start doing something now, because the companies that will be in the worst position if they have a breach or the regulator does an investigation are those that have done nothing. And if you can show that we're aware of POPI, we are doing the work, we're doing XYZ, that goes a long ways to the regulator saying, okay, well then we will give you the time to sort of finish it.
So is the company,
yeah, go ahead, train all
is the
employees,
company not required to train all of its employees? That's a big question. So let me break the question down. The company, as per the regulations written as per the law, there is no requirement to train all employees for POPI, but it is required that you train your key employees, specifically the information officers and deputies, on an annual basis, and that's mandated. That's number one. Number two, you are required to actually follow certain base guidelines for data protection, right? So as part of the base guidelines for data protection, one of the most recommended thing to do is train your employees for cybersecurity. Okay, so we would strongly recommend training all employees for cybersecurity. For example, that training could be, go figure out whether you get an email and whether it is a phishing email, whether you should open the email, download whatever it is, things like that. So employees are aware of cybersecurity, they have better password protection, and they have good sanity on their electronic usage and social media usage and things like that. That we would recommend. In our Pro package, we actually provide that, so you can actually send that training to all your employees. So that you should look into that. Okay.
And one of the things to keep in mind is, depending on the size of your organization, it's the requirement under the law is yes, training is good, especially on the cyber side. But in terms of the broader sort of, it's as long the employees that are dealing with personal information need to be aware of the policies that you have in place, right? And that the law exists. And so as a minimum first step, anyone dealing with personal data should be reading all the policies that you have and know what they should and shouldn't be doing with personal information. And then you build on that in order to protect the data. So
let me read the next question. The package for a period or a month-to-month scenario. The package is a month-to-month scenario. We are the only company in the world offering compliance on a month-to-month scenario. Okay, and it's what's called consumption-based and usage-based. You can come this month, pay 200 Rand on the Light Plus package, for example, and then decide, I've had it. We'll charge you by the end of the month, by the way, and we won't charge you at the beginning of the month. Okay. And do that, and you can turn it off. It's only 200 Rand for that matter, right? You can turn it off after you think you got enough out of it, for example. The next question is the training accredited once completed? We just said that.
No,
there is no accreditation.
There's no such thing, right?
No, so I want to be market.
Right. So we want to be clear. We do give you a certificate, and what that certificate would do is, if there was an inquiry from the regulator, you could say, we did complete a training, here's a certificate. It does not mean anything in terms of accreditation. The regulator may say, I don't care what you have for a certificate, but it's a way of demonstrating that you have done some sort of training, because at the current moment, there is not one that the regulator has said, yes, this gives you accreditation. If something is,
the chairperson, actually had come out and indicated that they do not plan to do any accreditation for any certifications or anything in the future. Okay, if they're
Yeah.
going to change their mind in the future, that's a separate issue. But
Yep.
we are not claiming accreditation. We are not claiming we are claiming that we are really good at what we are doing.
Right.
We can help
And
you with it.
Yep.
We can tell you what to do and how to do it, and we can show you how to do it. But we are not basically saying we are legally accredited or
Yeah.
whatever. Right?
Yeah. And the certificate is to give you proof that you have done something, right?
Participated.
Because otherwise they just have to take your word for it. And we would certainly, if somebody asked, we could confirm that you had completed the training. But that doesn't necessarily mean, not a safe harbor or legal clearance from the regulator. So
Yeah. And the next question is in a similar way, right? Can the company be safe from facing disciplinary actions if one of the employees goes against the act, even after they were trained? Is it possible to not suffer the consequences done by negligence? Yeah, negligence
Yeah,
is
I mean-
negligence, you know.
yeah, so like this it depends, right? Where I have dealt with this in the European context, right? If you have a rogue employee that does something wrong, you still might be fined, you might be investigated. I mean, it goes a long way for you to say, it's about then being able to show the regulator will still investigate, and it's about being able to show the regulator, look, these are all of our policies, these are all of our trainings, this employee didn't follow them. And then the question is, we knew that day that they weren't following them, and so we suspended them and we suspended their access to personal information. What's going to look bad is we have all these trainings and we didn't find out for 6 months that they were stealing personal information or something like that. And so it might lessen the blow from the regulator, but it's not necessarily going to put you in a position where you're safe, per se, right?
They might slap a small fine and would
Right.
definitely ask you to do rectification.
Right.
Would imply they want more controls to be put in place,
Right.
potentially. Okay, so
Yeah, exactly.
it's not the end of the world.
No, but doing all of these steps that we've talked about I call it telling a story, being able to tell a story to the regulator to show all of the good work you've done, because no matter how much work you do, bad things happen, breaches happen, employees do things that they shouldn't do, etc. And the question is, when those things happen and then the regulator investigates, how much can you show that you've done? Because if you have nothing to show, then you're at a much bigger risk than if you're than if you've done a bunch of work. So
absolutely. Now, having said that, we are on the hour. Thank you so much for your participation. Really appreciate it. If you have any other questions, we are here. Angel is going to reach out to you guys by email or even phone call sometimes. So please, and she's very nice. If she's not, I mean, she's extremely nice. Okay. So best of luck with your implementation. Do sign up. Angel will drop the sign up back on the chat again. Okay. And we are good. Thank you very much for joining, and best of luck with the implementation. Is there any other question? Last minute question? Okay. No, thank you. Excellent.
Thanks. Great.